There's somebody. Hey, Mike. How's it going, man? You there?
Can you hear me?
Yeah, there you go. Here you
Uh,
are.
how's everybody this evening?
Pretty good. Just working. Got deadlines, so grinding away. I was getting ready to call it, though, man. You showed up just in time.
Yeah, man, I was surprised. I was like, "Oh man, what's up? Did it cancel again?" But nah, and I got the message, so I was like, "Yeah, that's weird."
Yeah.
Um,
Yeah, it was last
well,
week. Last week I was out of town, so.
yeah, that's what James had sent out a message about.
Yeah. Yeah. So how you been, man?
Good, good. Just still working away at this defamation, and then also finalizing my um the federal one for the violation of civil rights here.
Be careful about your statute of limitations there, man. How long ago did all that happen?
January 8th last year is
Oh, okay.
the date I'm marking from. So that's why I'm finalizing now so that I can make sure that I get that in well ahead.
Yeah, that makes sense. You just want to keep in mind it's a 2-year statute and it's 2 years for
Right.
a wrongful act.
Right. So I figured if I get it in now, because even if they, what do you call it, dismiss it with or not dismiss it, but allow you to submit it because you don't have like the proper claims or whatnot, you're still good, right? You just have a certain amount of time from that point.
Yeah,
Uh,
once you file it, once you get it filed, then the statutes of limitations, at least on the claims arising from the facts that you put in your complaint, are told. So that means the statute stops running against you. And if the court does their review and they say, oh, you didn't adequately allege, XYZ, but you have leave to amend, that does not impact the tolling. The tolling is still in place, so all the clocks are basically stopped from the moment that you get that filed.
how long do they usually give you to resubmit the claim?
For a pro se, I don't really know. I can tell you
Okay.
from my perspective, when in fact I'm working on one right now where we're doing an amendment. We got blown out on a motion to dismiss, but with leave to amend, and the court gave us originally was only going to give 2 weeks, but then I requested 30 days. And so the judge gave us 30 days. So generally speaking, is if you need more time, you can ask for more time. And
Okay.
especially since you're a pro se, the judge will probably give it. So,
Gotcha.
so you should be okay.
Unless your initial is just so way out of the water that it's like, yeah.
Yeah, unless you're like totally whacked, then
Okay.
the judge may not even give you leave to amend.
Let me ask you this: for me trying to request or ask for adjudication or a summary of, I forgot what the other one, judgment. Because they sent in, what's that form? Let me get it real quick. Where they ask you, how long you think it'll be before your discovery is wrapped up, where you stand on the ADR, all that stuff. That form.
Hold on a second. Let me put on my headphones real quick. Yeah, you're talking about the case management conference statement. It's like CM 50 or something, right?
Right. So they sent one in, of course, initially, with the packet, and then they switched out. I guess one lawyer. Hold on.
Hey, you're not coming through clearly, man.
Can you hear me now?
Yeah.
Um, then they switched out a lawyer, I guess, from one of the lawyers from the firm to another, and then they resubmitted another one, and they're asking, they expect discovery to be completed in August. Now, can I file this, motion for judgment or summary? Because I don't see why they need time to research and investigate the, certain claims that they made. Because if you made these claims and they're based on truth and fact, you don't need time to research it. You should already have known, or have that information. So, is the judge going to allow me to file something like that, even though they state they need, they're in the early stages of discovery, and they estimate that to be resolved by August?
What was this particular discovery request that they were responding to in that way?
Proof that they had that I, transferred the car out of the caregiver's name into mine.
How long ago? How long ago did you file or serve the complaint?
It was June of 23, June 20th, something like that.
Okay, and have there been any rounds of discovery? I mean, have you sent them discovery? They sent you discovery, back and forth?
Yes, I sent uh, 2 or 3 rounds, and they were, rejecting them because, I didn't have the responding party right below the, case name, things like that. The real nitpicking, petty ones. Really, there was only one true round of discovery received by myself, and they also requested discovery, which I have until I believe the 6th of March to get within the 30 days.
Okay.
So I'm just drawing it out like they did, because I ain't gonna rush to give you something. You didn't rush to give me none. And
that's okay. That's what everybody does.
Oh, okay. And then I still have an option to request admissions. I'm gonna do, like, that I was researching that, send that form, that court form, along with the request for admission, so they have to provide all of that information.
Right.
I've done the only special interrogatories and requests for documents, but the documents that they send me are, felonious. There's nothing that ties me to anything, any of it. I mean, there's notifications. Just yes, their PayPal was closed. They accused me of hacking their PayPal account to close it, but nothing solidifies their claims or even points to me in the slightest of way. And I don't know why they need to or they're waiting till August to find this information that will never produce.
Well, one thing you can do, did you send them a form interrogatory 15.1?
No, I haven't done any form interrogatories yet. I was waiting till I submitted it to the request for admissions, and then I'm going to check all those boxes.
Don't wait.
Okay.
Just serve them right away a set of form interrogatories.
Okay.
Make sure that it includes form interrogatory 15.1.
Now, go ahead.
If you look at 15.1, what it requires them to tell you in excruciating detail is all facts that support their affirmative defenses and all facts that support their denials of material allegations. They have an attorney, right?
Yes.
Okay, what they're going to do, all the defense attorneys do this, and it's really bullshit, but they do it anyway, is they will just tell you, oh, we asserted a general denial as we're allowed to do, therefore we're not going to give you any facts. And as to all of our affirmative defenses, we just deny everything that you're saying, and they don't give you any facts, actual facts, to support their affirmative defenses. What you can do with that, once they give you that sworn statement, is you can file a motion for summary adjudication and submit their factually devoid interrogatory response to 15.1, and that meets your burden as the moving plaintiff on a motion for summary judgment. Because normally what you have to do, it's actually hard to meet your burden as the moving party on a motion for summary judgment normally, because you have to come in and actually show affirmatively that they either can't ever meet their burden at trial, or that you have some fact or evidence that negates their ability to meet their burden, which, that's just really hard for a plaintiff to do. But that burden shifting problem goes away when the defendants give factually devoid responses to form interrogatory 15.1, which they always fucking do. And what I can tell you is we're getting ready to file one of these on that exact basis against the county of San Diego. And if you remind me, because it won't be filed probably till Friday next week, I think. But if you remind me, I will send you a copy of the moving papers, and that should provide a pretty good template for you for how you do that.
Most definitely, I will not forget that for sure. Um, so go ahead and submit that, and then what you'll be showing as a template will show what you're going to ask the court to move forward with, because these guys, ain't got diddly.
Right, right. Now, obviously, the story is going to be different. The facts are going to be different. You don't
Most
verify the
definitely.
facts. But the law, the core of the motion will be identical because it's going to be based entirely on the county's failure to provide, evidence in their form interrogatory 15.1 response to support their whatever 50 something affirmative defenses.
Got you. Now I've been using this AI platform called Case Text. I don't know if you've been
Yeah,
familiar
yeah,
or
I'm
if you
familiar.
use it.
I don't use it,
Uh,
but I'm familiar with it.
yeah, so yeah, this one's pretty good in the sense of just getting history on similar cases and the complaints that were submitted and any summaries that were issued on it. Now I'm assuming that these long, like for example, mine is pretty much concerning like California Civil Code, and so the California Civil Code Section 47
Yeah,
talks about privileged definition and information,
right.
and they have these these long A, B's, one, two, threes, and all that. Now I'm pretty sure that a savvy lawyer probably uses uses one of the stipulations and picks and chooses. Like for example, I want to use California Section Code Section 47.2,
Uh huh.
which states that privilege does not extend to statements made in judicial proceedings if the statements are unrelated or not relevant to the subject matter of the proceeding.
Okay.
Now, I carved that statement out of the super long definition or summary, because not all of it was applicable, but also number 5 of that same section code 47 states that the subdivision does not make any communication privileged between a person and law enforcement agency in which the person makes a false report that another person has committed or is in the act of committing or a crime, a criminal act, or engaged in activity requiring law enforcement intervention, knowing that the report is false or with reckless disregard for the truth or falsity of the report. Now, that's the entire verbatim, uh, exception rule.
Yeah.
Now, the fact that do I have to prove that these were false before? Because I have a feeling that some of the admissions that they are asking me for, they're going to probably try to get the case thrown out because technically I can't really use this information yet until I get approval from the juvenile court. I'm pretty much gonna bank on that. But the fact that the information in the report is not true, does that allow me to request that it's not privileged at that point, or I'd have to prove it first?
That was a lot of information in that question. I want to make sure I'm understanding correctly.
Sure.
What you're wondering is whether or not to fall within the exception of Civil Code Section 47B5, you have to prove not only that the information was false, but that the person making the report knew at the time they made the report that it was false.
Right.
yes, you do. In order to meet the exception, you're going to have to prove, number one, that the information reported was false, and number two, that the reporting party at the time they reported either knew it was false or didn't give a fuck. You
Right.
know, reckless disregard for the truth or falsity means they didn't bother to check, they didn't investigate, they just made it up and did it.
Now, one of their responses to my interrogatories was, did they ever make any reports to the law enforcement agency on any of the so-called claims made against me? And they didn't. Now, to be honest, I feel like that's a blatant disregard for the truth, because if you're accusing me of attempting to break into your home, harassing your children, trying to steal your car through DMV, attempting to poison the family dog with cannabis, all these things, these are all criminal acts. In my understanding and definition of what they're accusing me, if you were so sure that it was me, I think any normal person would report that to the police department, not constantly run back to a social worker.
Well, yeah, and that's an argument that you would make, but that's not conclusive that, they knew it's not true. I mean, people don't report things all the time, but the fact that they made the allegation these things happen, and the fact that they didn't report, to the police that their house was broken into or their dog was poisoned or whatever, that would all be information that a jury would be entitled to consider in deciding whether or not these people intentionally falsely um, reported against you. Does that make sense?
Correct.
Yeah, it's not going to be conclusive. That's not something that you're going to win a summary judgment on. It's going to raise a tribal issue of fact, certainly. Mainly because shit happens all the time that people don't report. Somebody slashed my tires. I didn't call the cops. Does that?
Oh, she said I slashed her tires 3 times.
Yeah, well, that's happens frequently. I don't call the cops. In fact,
3 times though, in a row.
oh yeah, dude, all sorts of shit. People do all
Yeah.
kinds of funny things. So my solution, I just put up video cameras, got a baseball bat next to the door, and have a little alarm, a motion sensor, and I sit and wait. I'm not going to call the police. I'm going to beat the fuck out of them. So, I mean, people don't call the cops for all kinds of different reasons. So that's what I mean when I say standing alone. That's not going to, prove anything one way or the other. But it is evidence that a jury could consider in deciding whether or not the allegations were true.
Sounds
That,
good.
does that make sense?
Okay. Yeah, that definitely makes sense. Now I'm more worried about getting around the the privileged, because I mean that's not my entire case, because I do have witnesses that have also been told directly from the caregiver some of these claims. But a good portion of them um,
Hey,
were
hold on a
in the
second.
reports.
Hold on a second, Mike. This is for Love My Children. Would you mind, unless you're speaking, muting? Because I think we're getting feedback from your mic. Thank you. Go ahead, Mike.
Yeah, and I want to use the reports, because I mean 80% of the stuff that was in the reports were also told to individuals, so I'm not really too worried about losing the information entirely. But I wanted to use those reports to show continuous
Yeah, continuous
ongoing.
publication.
Yeah, and then I also was researching on what it takes to prove malice, and of course, by researching it, you cannot. The communication in itself cannot just be considered malice. You have to have, some underlying, proof that they, did this intentionally to cause harm, knowing that it was going to cause harm. So, I feel like with the 16 or 17 ongoing claims that they made, all of them being false, and them just continuing to make these claims in themselves, with any normal person knowing that there would have been a consequence in its action, naturally, I consider that would be my malice argument. What do you think?
What I would suggest is look at California jury instructions. Let me see. It's
Yeah, I was reading that, and I have the templates of what they have to, like, did this, plaintiff prove this? Did they do that? But there's like seven of them, eight of them. I'm not sure which one would directly apply to me.
I
You know,
would take a look at CACI number 3114.
okay,
Basically an explanation of malice, and what it says is malice means that whoever your defendant is acted with intent to cause injury, or that his or her conduct was despicable and was done with a willful and knowing disregard of the rights or safety of another. A person acts with knowing disregard when the person is aware of the probable dangerous consequence of the person's conduct and deliberately fails to avoid those consequences. Despicable conduct is conduct that is so vile, base, or contemptible that it would be looked down on and despised by reasonable people. So right off the bat,
which one were you at? CACI, which one?
3114.
314. Okay, I'm gonna get there with you.
Right, right
Yeah, I
off
was.
right off the bat, I would also look at your exception. You know that Civil Code Section 47B5.
Mhm.
Right in its definition, it has something that looks very much akin to the standard for malice, which is publishing a false report with reckless disregard of the truth or falsity of the report. Now that isn't necessarily, you know, gonna fit the rubric for malice, but it's pretty close.
Okay.
I mean, anything that you do with reckless disregard comes pretty damn close to meeting the definition for malice.
Right, because I mean, some of these, well, all of the claims, well, not all, but a lot of them you could have proved with just a little bit of due diligence, and to have done all of those and not really taken any other actions. And I don't feel like a lot of them even fall within the context of the juvenile dependency court case and what the proceedings and matters were, being discussed. I don't see how that all that she states, involves, or pertains to the child in the case. So, that's, some of my argument as well, that, none of this stuff even, applies.
Yeah, she was just coming in there to paint you black and make you look bad in the eyes of the court.
Right. I mean, that's my only, deduction. Why else would you do it? I never even had a conversation with you. I don't even know you. You don't even know me. But all of a sudden, you swear up and down, hand on to the Bible that, I'm doing all this stuff. Like,
Okay,
come on now.
there's another good definition for reckless disregard in that's CACI number 1603. And just for everybody watching, this is California civil jury instructions.
Uh huh.
And 1603, it's under the rubric of intentional infliction of emotional distress, but it's going to be more or less the same for anything that requires a showing of reckless disregard or malice. It says defendant acted with reckless disregard in causing plaintiff emotional distress if the defendant knew emotional distress would probably result from his or her conduct, or gave little or no thought, that's reckless disregard, gave little or no thought to the probable effects of his or her conduct. So that's another way to kind of, look at these things. And then if you look in the sources of authority and use notes, that's always a good source of information on further defining the rubrics that you need to meet.
Okay. Yeah, I stumbled across that jury instructions in the case text, because it brings up not only what you're asking for, but related cases that you may not realize also pertain, and then they have it like broken down rulings, a bunch of nice different ways to view it. So I've been getting a lot out of that platform as well. But I'll let somebody else go now that we have some other guests here.
Sure, yeah, no problem at all. Love my children. You have questions or anything?
Yeah, sorry, I'm new here. I'm trying to figure out how to use things. I do have some
Sure.
questions. I am planning to do a 1983 federal lawsuit very soon. My deadline's coming up soon,
Okay.
and I am kind of struggling in the details because, of course, I want it accepted. So I know I have to be general. But one question is, I mean, I have a lot of plaintiffs. I think there's an argument, especially because I'm solo and I'm not an attorney.
You
Um,
hold on. Do you mean that you have a lot of defendants? Because when you say you have a lot of
oh, sorry,
plaintiffs,
defendant. Sorry, yes, I have a
okay,
lot of defendants. Just one plaintiff.
yeah, right,
Um,
okay,
I have right now. I have 23 defendants.
wow, that is a
I
lot.
know. I know.
Where are you located?
I'm in Hawaii.
Okay, so you're still Ninth Circuit, so that's good. Um,
Yeah, they delayed the adjudication hearing in my case for 19 months and they danced around switching off. You know, they changed hats a lot. So I got lots of caseworkers and lots of people involved. I contacted a lot of people all the way up, wrote a lot of, served
okay,
a lot of letters and stuff. So
okay.
I involved everybody.
What's the nut? Just the nut in 50 words or less. What's the nut of the story of your case?
They took two kids without a warrant based on a false allegation. No circumstances of imminent harm. No drama. Like a teenage daughter made a false allegation. After a 5-day delay of the event, she alleged she had 3 small bruises. Later claimed 2 of the bruises were from skating. So like the claim itself is pretty weak. My 3-year-old daughter was taken. They were both taken for 2 years. They were
Holy
placed
shit!
in a placement where they were harmed, abused physically,
How were they harmed?
mentally, possibly sexually. They placed them with a sex worker, an older half sibling that was estranged from the family that influenced the teenager making this allegation. Unfortunately, has some mental health issues. I I contacted everybody as far up as the director of the DHS here, the ombudsman office, everyone I could think of. I mean, the mayor, the governor, all to no avail. In 9 months of abuse they endured. I know that I can't sue on their behalf because I'm pro se right now. I can't find a single attorney to take on the case over here. I mean,
Do you have either of the kids back in your custody?
no, after 2 years, and I did the service plan pre adjudication, they made a lot of rulings pre adjudication. It took 19 months for adjudication to happen. Over my objections, I got real loud and acted smart, and I think they really doubled down on me. Really, things got worse after they discovered the placement I warned them about being dangerous proved to be
Mm-hmm.
dangerous. Like, I feel like they doubled down.
So did they
There was a
move? Did they move the kids then?
Well, they moved the kids to a new placement, and then they ended up moving my older daughter 5 more times. They separated her from the sister. She
Mm.
claimed abuse in the next place, and they only changed her placement, not the sister's. Um, 2 different fathers. So the younger one's dad got involved, and kind of the grandma was interested in custody. So they kind of use that as the angle, and so it's called CWS here, really
Mm-hmm.
aligned themselves with the father. And they said the reason they wouldn't do reunification with me was because I wasn't admitting fault and because custody wasn't figured out with the dad, who previously had been uninvolved and did not have paternity. They gave him paternity and they gave him the kid, even though he was not involved before. It's really the grandparents that have the younger kid. So she's 5 now. She was 3 when she was taken. I still
Okay.
see her. Now I see her 2 hours a week, unfortunately in the custody. So that's an aside. The custody case is just starting, and all they hear is that CWS was involved. So it prejudiced me. They did kind of they called it reunification, but they took her from me and gave her to the dad's family. So
Well,
that's,
it's reunification with the father is what it is.
yeah.
But they did not terminate your rights, did they?
No, no. So now I'm in a
Okay.
custody thing solo. I'm dealing with the custody thing on my own. And I also appealed them closing the case and handing her to the dad. So I'm appealing it really just to bother them.
Okay.
Um, So then on the older daughter, who's 16, they recently placed her with a 30-year-old single male she was requesting to go and stay with.
Oh wow.
Allegedly, I asked the guy in court because he showed up, and I highly suspect that he was a previous client. I'm
Oh
saying
shit.
John, of
Yeah.
the daughter that was abusive. And I think that he could be a boyfriend. He has the look about him, like he looks a little young. I don't know. So
Yeah.
she was requesting for a year to go to him, and they said at first it wasn't appropriate because he was a single male. He's a DJ. He's.
Yeah.
And then they went ahead and placed her with him. I put an article in a local paper here and made a big stink about it. And so what they did to correct it was, because they said that was against their policies, to place a 16-year-old, which is the age of consent here, with a
Oh.
30-year-old male. They moved in a daughter who just turned 21 officially on paper to say that she lived there, but I know that she still lives with a boyfriend at a different location. It was just to look good on paper. The daughter is also homeschooling. As soon as she went and lived with him, she said she had social anxiety and now she doesn't go to school anymore. So there's ongoing concerns with her and a permanency hearing coming up. But regardless, I'm hitting the 2-year mark as of March 6th. So I need to go ahead and, file my
Yeah.
1983 lawsuit.
Yeah.
I'm looking at doing it in federal court.
Yeah, I
And
would do it.
because of
I
all
would.
this
I would do it in
negligence,
federal court. You're not going to get anywhere in state court. It's very political.
yeah, and I've been in 2 articles really publicly. I'm defending my rights too much. So one question I had going on is I didn't want to complicate my complaint. Is I'm looking at adding 2 of the DAGs on the deputy attorney general, because 2 of them were involved in signing a lot of orders pre-adjudication and doing a lot of underhanded stuff,
I
and
would
also the
not.
guardian
Hold on.
item.
Stop. I would not sue anybody who is acting in a judicial capacity. That's going to immediately tarnish your lawsuit, and that's like your first impression with whatever judge you end up with. You'll never.
Okay.
You'll never recover from that.
Okay.
So do not sue anybody who is acting in a judicial capacity.
Okay, well, maybe I
If
shouldn't do the other
are,
thing I was about to do this week. I'm about to file a judicial complaint against the judge.
well, no, that sort of stuff is okay because that's not
Okay,
going to end up in your complaint in front of a federal district court.
okay,
But in a federal district court, if you come in and say, "Hey, the state court judge fucked me over. I want to sue him and get money," they're just gonna shit all over you. So
yeah. Well, the deputy attorney general is the acting counsel for DHS, and he signed a lot of the,
he's
to get
he's
the title.
he's
But
he's
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 still
gonna have prosecutorial immunity. I wouldn't sue him either. It's a waste of time.
okay.
Unless,
Okay,
unless he signed something under penalty of perjury that wasn't true, that he knew wasn't true, that was material, then you can maybe go after the guy. But usually the attorneys are not signing shit under penalty of perjury. They're just signing filings, and they have the social workers sign the declarations and affidavits. So
yeah, they
it's always
signed a
going to
lot of
be.
child protective acts. They did a lot of filings pre-adjudication. They did 4 periodic reviews pre-adjudication. I'm at the permanency hearing coming up.
Yeah, well,
It was all done pre-adjudication.
the person that you would sue is going to be the person who's actually signing the evidence or providing the evidence. It's very, very rare that
Okay.
a prosecutor will be the one signing their name on evidence.
Okay.
You can't sue them for advocacy. That's their job. They get
And then
immunity.
I can't really sue the guardian ad litem either, even though he ignored my concerns about the placement and they were abused for 9 months. They all just completely disregarded me. I mean, I know I can't sue the judge very easily, but I did a motion for immediate review and they ignored it. And I laid it all out for them why I was that concerned. I was like, please place them even with a stranger over this person. They're in danger.
That's you're not going to get the guardian ad litems either. They're court of
Okay.
appeals. They're going to have quasi judicial immunity. I wouldn't bother with it. You're gonna, I mean, just go with what you have that's strong. And it
Okay.
sounds like you have a maybe I don't know all the facts, but maybe a good warrantless seizure case, and maybe a judicial deception case against the particular workers who submitted their reports all
Yeah, I
these
have
other
proof of perjury because I've been recording everything from day one. From day one, I knew not to trust them. So I recorded the initial interview that turned out to be an interrogation with a investigative social worker. I mean, I thought I would just, if I was just candid with them, I would get the kid back. I was really naive, of course, to begin with. I
yeah
had no idea.
you don't talk to those people,
I
but
had no idea it
yeah,
was like
but
that.
are you on you're on Patreon, I assume, right?
Yeah, I just joined, and so I have been watching your depositions, and I've got my claims sort of drafted, but I feel like it's a bit lengthy because I was looking at the actual directions, and so now that I cut out some of the defendants, maybe that'll be easier. But it says list like what each defendant did wrong, and
Yeah.
it's like, okay, well, a lot.
Yeah, well,
Um,
if you're just going after judicial deception, I mean, look at any one of our complaints there that has a judicial deception component. You really don't need to plead that much. You're going to say social worker Jane filed a report on X date. In that report, she said XYZ. At the time she made the report, she knew XYZ was false, but she reported it anyway. She signed it under penalty of perjury, expecting the judge would accept it into evidence and rely on it. That's
yeah.
it. That's
Okay.
literally it.
Okay.
So just take a look at how we've done that on any one of the judicial deception claims, and that should give you some pretty good guidance.
Okay. I saw in somebody else's complaint that they submitted, just a family advocate here shared a complaint that somebody filed, and it made me think. So I'm, of course, doing it under 42 USC 1983, but then there's other USC codes that I found that pertain to the situation, and I'm wondering, can you list those, or is that null if you've already done it under 1983? Because it was
No,
like,
if you've got something, if you've got a federal code that creates a mandatory duty on the part of whoever you're suing, then yeah, there's a possibility you can go after it. There's a case called Blessing. I don't remember who it's against, but you'll want to read that. It's a very tough rubric to meet. The easiest way to do it is the tried and true. Just follow the templates that we've got on there. There's a reason
okay.
there's a reason we don't go after all this other shit that people want to go after. It's because number one, it's complex. Number two, it's really difficult. Number three, the judges don't like it, so you're unlikely to win.
Okay.
Now the same can't be said for like 42 USC section 671A and 675. That's the Adoption Safe Families Act. If you are the child or you are a foster parent and the state or the government, county, whoever, doesn't meet the requirements of that statute, then you would have a claim to enforce that statute under 1983. But
Okay.
that's not going to apply to you as a parent.
Yeah, and I can only do me as a parent right now.
Right.
Yeah, it was informational to hear some of the stuff he was talking about proving malice. I mean, I'm gonna look into that. But the three I had listed were custodial interference. I mean, maybe that's a little redundant, and it's a Hawaii code. And then it's USC, it's 18 USC 242 deprivation of rights. That's
a criminal statute. You have no authority to enforce it.
Oh, okay. And then 18 USC 241.
Nope.
That's the same. Okay.
Yeah, the only thing you're gonna have any ability to do is going to be 42 USC section 1983, and even if you have some other federal statute that you're seeking private enforcement of, it's still going to be under the rubric of 1983.
Okay. And then I'm also going after police officers. I forgot to mention that. So I was falsely arrested. It wasn't a good and then they prosecuted me aggressively, like they raised the charges to a felony, all that. I always said, somebody told me to say every time I went in court, I'm ready for trial today, judge. I do not waive any of my rights. So they eventually did dismiss the criminal charge, which was abuse of a family member. I didn't do it. I have hard evidence of being at a different place and doing different activities of the timeline. So I actually wish I'd had a trial. but they never wanted to bring it to trial. So that's where I was getting into, like, I don't know if that becomes a separate thing, like malicious prosecution. And there's a recent Thompson case here.
Potentially, but remember, look at on Patreon. I don't know if it's up there yet, but the order in Hipschman. I guess you could have malicious prosecution because they did prosecute you criminally. So that's worth taking a look at, probably.
Okay. Yeah, I mean it affected my life. I was here visiting. I got invited to visit the grandmother here, and I was about to leave for a job, and I've been held here now since everything started.
What
like
city are you in?
I'm in well, the closest city I'm to is Hilo. I mean, I'm in a tiny little town, but it's Hilo where this is all happening.
Okay, so you're actually on Hawaii?
Yeah, Big Island, yeah.
Okay.
And I was living in Arizona, and I came here to visit. The dad had just come out of the woodwork after not being involved. He'd abandoned the baby the whole time. He told his grandparents about her, and the grandparents invited me to come visit. And about a month later, all this happened. So it's kind of a convoluted thing because I think it was actually a custody grab. And the grandma has worked in the child welfare system here for 30 years before she retired as a foster parent licenser. So she really understood how to work the system. That's where I know that gets really complicated, so I'm not trying to touch it, and I want to make friends with the grandma because she's still the grandma. But there really was a conspiracy element here. Yeah. She's Hawaiian. I'm a Haole girl. I'm white looking.
Yeah, I wouldn't screw around with any of that. Hey, listen, we got about 10 minutes left, and we've got one other viewer, J-Dub here, who may have a question. I'd like to break away from a bit and see what he's got going on. And if nothing, then, I mean, we may come back. But let's hear from J-Dub.
Okay, thank you.
Sure, thank you.
Hey, what's up, Sean? So, right now I'm trying to work on getting a restraining order dismissed at least a year early because it's set to expire sometime in October of 25. Mm-hmm. But I have a lot of stuff basically that I've done to rehabilitate myself, and then on top of that, been trying to learn how to fill out subpoenas and ask for them, and was studying your work a little bit, so that did definitely help.
Nice.
And I guess another thing I want to do to this guy, because this guy has been essentially locked up, and his wife have been both arrested before for domestic violence. And well, I was reading about how guardian ad litems work, and I know that if you could, if I'm correct me if I'm wrong, but if you could prove that they breached their duties as a guardian ad litem, right, would that possibly also be a way to dismiss the restraining order or not?
Oh, geez. On that's kind of outside my area, but I don't know. My feeling is that you're not, unless it's your guardian ad litem, I don't know that you're going to have standing to assert any kind of breach of duty. So that would be just my gut feeling. I haven't done any research on this issue at all, and it's sort of outside my practice area. But just on base knowledge, that would be my gut feeling. I don't know whether that's correct or not.
It sounds about right. And then, I guess since we have a short amount of time, I was going to tell you, so they had a Q&A for that meeting I mentioned in the chat.
Yeah,
and
I was thinking about that. And just so everybody else knows, the question that he had posed in the chat was, did you hear about the San Diego Town Hall meeting regarding what San Diego CPS and the juvenile courts plan to do? And my answer was no. So yeah, fill us in. What exactly is that all about?
So it was on the 22nd of this month. It was posted on the SD Court website.
Oh, so a couple days ago.
Yeah. So then I asked myself, like, what kind of question would Sean McMillan ask? And the best thing I could think of is, like, so what are you going to do to assure that the workers are going to get the proper training and get aboard on this plan? And what's going to happen if they don't?
But what's the plan?
So I guess they're trying to do their best to avoid foster care intervention. And I guess they're more in favor of placing kids with family members rather than a foster parent. That's what they say their plan is.
The law requires that, so it makes sense that that would be their plan.
I mean, who knows? Hopefully, like, something's getting better. But I mean, I was surprised.
What? 1 second. I got 10 more minutes. Sorry. Go ahead.
Yeah, I was surprised. When they read my question, they were all talking about it for a good minute.
So, what was your question?
Oh, it's just like, what are they going to do to make sure the social workers are properly trained in this plan, and what's going to be done if they don't? How are they going to be held accountable?
Oh, I like that. And what was the response?
And well, one person on the panel was like, "Oh, that's just a comment," and then the director stepped in and said, "No, that's actually a good question." Then she started breaking down how their disciplinary system works and how their coaching system works, and basically other people, I think the assistant director and then a few other people started basically going over, like, "Oh, well, we said it in this part, and this part, and this part." I'm like, well, sure hope they do.
Oh, how interesting.
Because, I mean,
do you know whether or not they recorded any of that?
they did, and since they said they were recording it, I mean, I recorded it from my end too, so.
Shit, send me a copy of the recording. I'd love to hear what they had to say about all that.
Yeah, definitely. I mean, just, do you want me to send it to you on Discord, email? What do you prefer?
Just email. Send it to either capsonstemslaw@gmail.com or to cpslawyer@gmail.com. Either one works.
Alright, I'll definitely send it to you so you can check it out and see what you think of it.
Yeah, that's actually really interesting. I'll have to get online. Also, send me the link for where you found, that on, or was it online or it's from what?
Yeah, it was online. So if you go straight to the sdcourt.ca.gov website, it was it's still posted there for some reason. Yeah, it's like literally at the bottom. They had a virtual meeting. So if you click into it once you got into it, there was like this little via Zoom highlighted, and it took you directly to the link. That's how I found it.
That's cool, man. Yeah, I'll go check that out. In fact, maybe I'll do that tonight once I get home.
And then apparently they also have quarterly meetings with the juvenile courts too. And I don't know if they do it with any other courts, but I found that they do it with the juvenile courts, which is interesting.
Yeah, it sounds somewhat incestuous, right? It's like the agency that's taking kids and always appearing in front of the juvenile court to, lambaste parents, goes and has lunch with the juvenile court every month. It's like, I don't know. That just looks funny to me.
I mean, I just find it odd that a court like that could have so much power, and then you're not even allowed to face your accuser.
Yeah, well, they're not. The judges down there aren't having lunch with me, right? I mean, they're not meeting with me. They're not meeting with you, but they'll go and meet with the director of the agency.
I mean, they're scared of people like you, man. You know how to hold them accountable. That's why.
Fuckers. I guess I shouldn't say that.
In a perfect world, everybody get along, and then you'd probably have to choose a different field of law. But they keep screwing up.
Well, that's the thing that I tell people all the time is, look, the government can put me out of business anytime. It's actually really, really easy. I live in a very, very precarious position. If they thought about it, all they have to do is follow the law, and I'm out of business. It's that simple. But the likelihood of that happening, I thought in the beginning, 15 years ago when I first started doing this work, I thought, oh, you know what, this is going to be like a flash in the pan. Just going to do a couple cases. All these agencies will get their shit figured out. That'll be the end of it. So I, go back to my normal life. That was 15 years ago. And I'm still doing this shit. And they're still not fixing it. And it's like, guys, I mean, come on. This is not rocket science. But, yeah, my hope of fixing the system died a long time ago.
Yeah, pretty much. I mean, the person who taught me about how to like read and write law, not the sovereign citizen crap, like someone who actually knew what they were talking about. He had a saying that he told me. It's like, don't go to court looking for justice because you know where you're going to find just us.
Yeah, right. Right. Yeah, that's a good line.
I'd like to disagree that you gave up on fixing the system a long time ago, because sometimes in order to fix something, you have to do it, one case at a time, one individual at a time. We would hope that it would come, as a reality check in the grand scheme of things, but you get closer to a grand fix each time you take a case. So I say you are still in pursuit of that, and as long as you continue, changing one, life at a time, then it'll eventually happen.
Well, I appreciate your positivity and your optimism, Mike. And I agree to an extent that, it's by these successive iterations. You get one policy change here, you get another one there. They kind of accumulate, and then it makes a difference. But, it's tough going. Hey, guys, listen, I've got to get going a couple minutes early tonight. I've got dinner that I'm actually going to bring over to my parents and pay them a little visit. So I hate to cut you off, but I'm going to have to roll out. Thank you all very much for attending. And
Thank you.
We'll talk to you all next week. I know James has a live going on tonight. I won't be there because I'm going to be over visiting my folks, but there is going to be a Depot play on YouTube at 6:30. So if you can pop in there, that's great.
Sounds good. Enjoy dinner. Have a good one.
All right.
Thank
thanks,
you.
man.
It was nice seeing you, Sean. Have a good one.
Yeah, you too. You too. We'll see y'all, and hopefully you get your case filed on time. Love my children. Get your case filed on time, and hopefully it'll work out. I'll be here next Sunday if you have further questions.
Okay, thank you.
All right, sounds good. And then be sure to grab your popcorn and be on the watch out for your email because you're going to enjoy what I'm going to send you.
Yeah, I'll watch for it. I'll look for it tonight. Cool. Thanks, man. See
All right, have a good night.
You too. Bye.